So good morning, everyone. It's great to see you. We are about to embark on an exciting panel on the rules and methods of interpreting international criminal law. First of all, I think a warm thank you for the TRICI organizers to put us together in such an impressive venue with such impressive colleagues. I think it's a true privilege to be here and to share this moment of the project with you. We have an exciting panel. ICL is, of course, a special field if we look at interpreting international law in light of the principle of legality. We all know it's been interpreted in a flexible fashion in light of Article 15 ICCPR. However, with a gradual Nuremberg started by qualifying it as a principle of justice, but we've seen that over time, obviously the principle of legality has become much more concretized with treaty instruments through subsequent practice. So now it gets, I think, much greater attention. We all know that the ad hoc tribunals developed their jurisprudence largely based on customary international law, whereas the ICC as a treaty system is much more constrained. If we look at the ICC, I think we see in relation to the crimes that the ICC has more or less stuck, I think, to the interpretation and the guidance which was given by the drafters and then through the rules of procedure and evidence. However, if we look at modes of liability, we already get a slightly different picture because here the statute is very much ambiguous. And although the ICTY qualified joint control over the crime as customary international law, the ICC didn't feel compelled to follow this qualification. Instead, it adopted the concept of joint control over the crime and adopted some new concepts just like indirect co-perpetration. So here we see how also the ICC jurisprudence stands certainly in a certain tension then to the jurisprudence of the ad hoc tribunals. If we look at jurisdiction again, I think we see that here the ICC again did not feel constrained by the principle of legality. On the contrary, we see to some extent the argument of effective interpretation being applied. If we look, for instance, in the ICC decision in relation to jurisdiction in relation to Myanmar, the ICC adopted, it didn't go so far to adopt the effects doctrine, but it said it's sufficient if one of the constituent elements of the crimes is committed on the territory of a state party in order to give the ICC jurisdiction. So looking at this macro picture, it seems there's really not only one way of interpreting ICL, but there's actually a plurality of ways of interpreting this field. Secondly, I would say sometimes judgments can get it wrong. The ICC appeals chamber recently in the Al-Rahman decision, which you might say is a little bit the ICC Tadic decision, pronouncing itself on the scope of the principle of legality if the ICC has to deal with individuals from non-state parties. Here the appeal chamber followed the Tadic methodology by saying that the ICC in relation to non-state parties should rely on customary international law based on the principle of legality, but then it made this rather broad striking statement that the statute was intended to be greatly representative of the state of customary international law when the statute was drafted. So a kind of underlying assumption that everything that we have in the statute is now part of customary international law. So I would argue that this is misguided. I think if we look at the drafting history, if we look at the statute, we see that sometimes the ICC statute is more restrictive than customary international law. For instance, if we look into war crimes provisions, sometimes the ICC might also be more progressive than customary international law. And we see that, for instance, I think in relation to sexual and gender-based violence, where the ICC has really shaped, I think, also new ways of going forward. In terms of methods of interpretation, I think some of the methodologies face critiques. It's convenient, obviously, to rely on object and purpose. in order to avoid the sometimes burdensome journey of identifying general principles. If we look at the ICC jurisprudence, I think we see that from a comparative perspective, it has been rather selective in relation to how it's also looked at domestic legal systems. I remember an early incident in ICC practice when the appeal chamber had to determine whether there's a right to an extraordinary remedy, even though the option of leave to appeal is not provided in the statute. So the appeal chamber then tried to look and identify, based on the search for general principles, whether there is such an avenue for the prosecution based on general principles. But again, if we look at that decision, we see, if we look at which systems of jurisprudence are decided, again, it's a little bit the preference of judges who guides this choice. So I think there's more groundwork to be done. So this is, I think, maybe a short overview to some of the general questions which we're going to discuss at the panel. We have three excellent presenters. I don't think they need a lengthy introduction. Olympia Bekou, who is head of school at Nottingham, will speak about the impact of national legislation on the future interpretation and application of the statute. And this, I think, is really interesting if we also look at how implementing legislation has partly deviated from the statute and also adopted sometimes more creative approaches, and how this would then spin back, I think, on the interpretation of the ICC is indeed, I think, a fascinating question. Then we have Caroline Fournet, now back at Exeter, former Dutch colleague here. She will ask how the ICC used national law, particularly also when identifying general principles. I think this is, again, a really important paper because it hasn't been really analyzed to what extent and how the ICC actually used national systems when interpreting the law. And finally, we have Leila Sadat from Washington University, St. Louis, who will speak about overzealous interpretation of the ICC statute. So I think, again, a fascinating take. So without further ado, we proceed with the three presentations, and then we move into Q&A. So Olympia, the floor is yours.
Thank you very much, Carsten. Good morning, everyone. It's a pleasure to participate in this conference. Thank you to the organizers, and thank you for the excellent discussions so far. So, as Carsten said, in my presentation today, I shall focus on interpretation in the field of international criminal law and the influence of custom as an aid to interpreting core international crimes. So in particular, I would like to consider the role of the national implementing legislation and the role it plays when interpreting crimes in the Rome Statute. 20 years have passed since the entry into force of the Rome Statute, and in those 20 years, international criminal law has developed and has become the vibrant field that we have today. Whilst the ICC is and should be at the center of the system created by the Rome Statute, states continue to have a critical role in investigating and prosecuting core international crimes. And this is because of the principle of complementarity. So for states to be able to do so, they need to adopt national implementing legislation, incorporating the crimes at the domestic level. And in this process, as Carsten has already mentioned, several states have diverged from the Rome Statute when interpreting it. But what happens when there is a clash and core international crimes are interpreted differently within and outside the ICC? In addition, what happens at the interface? So what I'm trying to do today is to unpick this interaction between the Rome Statute provisions and legislation which has been enacted at the national level, because I feel it can offer useful insights into the practice and evolution of core international crimes. So moreover, I would also argue that it can contribute to a better understanding of the rules of international criminal law interpretation, as well as pave the way for possible statute amendments. I said already, we are celebrating the 20th anniversary since the coming into force of the Rome Statute, but it is important to remember that the Rome Statute is the product of intense multilateral negotiation. And in order to reach the widest possible consensus among states, it was understood that the Rome Statute was, as our dear friend Rob Cryer had put it, it wasn't the right place for progressive development of the law into uncertain areas or for the elaboration of new and uncertain international criminal law. Moreover, there were concerns about retroactivity and compliance with the principle of legality following the Nuremberg and Tokyo international military tribunals. And since then, every effort had been made for core international crimes definitions enshrined in international criminal tribunals to reflect customary international law. I mean, this is in response to the victor's justice criticism of the Nuremberg paradigm. So the adoption of the Rome Statute in 1998 provided a further opportunity to crystallize customary international law at the time. However, drafting an international treaty is always an arduous process. It is very hard to hold the narrow line between pure codification of existing customary international law and progressive or even retrogressive developments. There are a number of compromises in the statute. So in order to build consensus, states had to diverge from the existing content of customary international law at the time. And Carsten already mentioned some examples. I'm going to mention a few more. The Rome Statute in places shows both limited progressive development, but it also contains instances of regression. So it is not completely reflective of customary law. Take, for instance, the inadequate codification of prohibited weapons, the exclusion of legal prohibition on the use of weapons of mass destruction, as well as the lack of prohibition of conspiracy to commit genocide, and so on and so forth. Yet, international criminal law is not intended to be frozen in time. It changes, develops, and evolves continuously. The Rome Statute itself recognizes that the ICC does not operate in a vacuum. So look at Article 10 of the Rome Statute, and I quote, "Nothing in this part shall be interpreted as limiting or prejudicing in any way existing or developing rules of international law for purposes other than this statute." So therefore, the exclusion of certain crimes from the Rome Statute or departures of customary law is not intended to prejudice the existing customary international law framework or the progressive development of new customary law in international law. We are at a stage in which customary international law has considerably developed alongside the Rome Statute, including through the national laws of states. So going back to legislation, the statute does not expressly require states parties to enact domestic implementing legislation incorporating the crimes in a uniform manner. So states are afforded wide discretion when carrying out the implementation task. And there are substantive differences as to how core international crimes have been interpreted when transposed into national systems. So, for example, whilst a number of states have replicated the exact wording of the Rome Statute or made explicit reference to its relevant provisions, others have reformulated, rephrased, and redrafted the conducts criminalized in the Rome Statute. So some states have adopted narrower definitions of core international crime. So, for example, omitting racial groups or ethnic groups in the domestic definitions of genocide, or adopted restrictive definitions of torture or enforced disappearances of persons. Conversely, others have employed definitions based on general international law, other applicable treaties, or new developments in customary international law. Several states, for example, Latin American states or post-Soviet countries, have expanded genocide by increasing the number of protected groups. or broadening the list of punishable acts to include displacement or deportation. Other states, like Germany, have also included some conducts that have been omitted during the negotiations of the Rome Statute. Take, for example, the prohibition of the use of chemical and biological weapons amongst war crimes, or blurred the distinction between international and non-international armed conflicts. Yet, they all purport to criminalize the same conduct as that enshrined in the Rome Statute. With the principle of complementarity being the cornerstone of the Rome Statute system and the ICC operating as a court of last resort, the primary responsibility to investigate and prosecute core international crimes rests with states. The ICC can only step in and intervene and take over if the states are unwilling or unable genuinely to do so. However, when the ICC does step in, what would happen if national core crimes provisions differ from those found in the statute? The judges of the International Criminal Court are tasked with interpreting and applying the Rome Statute. The rules of interpretation employed by the ICC are clearly laid down in Article 21 of the Rome Statute, which places primary importance on the text of the statute, its elements of crimes, and the rules of procedure and evidence. Residually, judges should also apply applicable treaties and principles of rules of international law, as well as general principles of law derived by the courts from national laws, including the national laws of states that would normally exercise jurisdiction over the crime, which is, I think, what Caroline is going to talk about. But these rules of interpretation seem to provide an imperfect solution, in my view. They only apply to the court itself and fail to take into account how states behave within the Rome system of justice, which has been created by the statute, outside it, but in any case, not before the court. As customary law and general principles of law will continue to evolve beyond the statute, and new relevant treaties between states will be enacted, the definitions of crimes cannot be considered frozen in time. They need to be interpreted in the light of the law existing when the crime is alleged to have been committed. As an international treaty, the Rome Statute is also subject to the rules and principles of interpretation codified in the 1969 Vienna Convention on the Law of Treaties. Specifically, according to Article 31.3 of the Convention, we heard a lot about it in the past day or so, judges are required to take into account subsequent agreements, practice, and law when interpreting a treaty. Now, the interplay between Article 21 of the ICC statute and Article 31.3 of the 1969 Vienna Convention on the Law of Treaties puts ICC judges at the interface, taking into account subsequent agreements, practice, and sources of international law, including custom, when interpreting the Rome Statute, raises questions of how domestic implementing legislation can influence the interpretation of the definitions of core crimes crystallized in the Rome Statute, particularly when the court steps in accordance with the principle of complementarity. Let me tease this out a little bit more. How would potential new state practice and emerging customary law interact with the treaty provisions? And what does this mean for their interpretation? What happens, for instance, in a situation where a state party conflates international and non-international armed conflicts, and the court steps in owing to complementarity? Does the court still have to distinguish between the two as per Article 8 of the Rome Statute? A systematic and concordant practice of states interpreting and applying the definitions of core international crimes at the domestic level can contribute to the evolution of customary international law. And I would argue that it is that can essentially provide a problem. So it is actually we have the definitions of the crimes which are contained in the statute, and we need this systematic and concordant practice to determine what these definitions mean in terms of customary international law alongside what is contained in the statute. So take, for example, if a number of states parties that have enacted a particular definition for a crime that departs in some way from the formulation in Article 6 to 8 bis of the statute, it could be argued that a new state practice or opinio juris has emerged in respect of the content of the elements of that crime under customary international law. For example, a number of states consider direct attacks against civilian objects, disproportionate attacks, or human shields to be war crimes also in non-international armed conflicts, even though the statute only recognizes these as war crimes solely when committed in the course of an international armed conflict. However, the International Criminal Court is bound by the principle of legality. Whilst a certain level of flexibility within the statute's framework is admissible, the Rome statute cannot be stretched to create new criminal prohibitions that would then be applied retrospectively. It is therefore necessary to distinguish between the creation of new substantive law and interpretation within the scope of existing law. Whilst a reinterpretation based on subsequent practice can be considered acceptable, if it can be reasonably accommodated by the actual text of the statute, modification of the text under the guise of interpretation is not permissible, in my view. For instance, ICC judges could not extend their subject matter jurisdiction to the war crime of intentionally directing attacks against civilian objects, as this would broaden the punishable acts beyond Article 8(2)(e) of the Rome Statute. So I have a confession to make. As I was preparing my presentation, it struck me that the approach I'm putting forward today may come across as a bit conservative, or perhaps unduly conservative. We have, after all, seen brave acts of judicial activism in a number of instances in the past, including before international criminal tribunals. I mean, Carsten mentioned the Tadic moment in the ICTY. However, when we're looking at the ICC, the statute's provisions, although they offer some flexibility, are not fully flexible. It is important not to try and stretch them beyond their intended scope. So my advice to ICC judges, should they ever ask for it, is that they need to be cautious when taking into account subsequent practice and custom that significantly narrow or broaden the scope of a crime. Whilst being mindful of developments in state practice or customary law, they must also recognize that the statute is a treaty, and it is the Assembly of States Parties that can initiate amendments to the statute following Article 121 process. For example, a unified approach to war crimes committed in non-international and international armed conflicts could only be taken by the ICC if an amendment were to be made to Article 8(2)(e) of the Rome Statute to incorporate analogous provisions to those found in Article 8(2)(b). However desirable this may be, and even though a trend is beginning to develop in national legislation to conflate the two, the statute provision remains abundantly clear. But as Leila and I have been discussing recently, we could, in the situation of Ukraine, for example, fit some of the acts of aggression, which for jurisdictional reasons can't come within the ICC, under the crime against humanity of persecution. I think that's acceptable. But going back to interpretation and to conclude, ICC judges ought to be cognizant of how state parties have implemented core international crimes in their domestic laws, where engaging in the interpretation of the Rome Statute. It may be that some flexibility within the statute exists, and some judicial creativity may be inevitable or indeed welcome. but where reinterpretation based on subsequent state practice cannot be reconciled within the text of a specific provision, formally amending the statute remains the only route. Thank you.
Thank you, Olympia, I think, for really nicely setting these debates into discussion. I think you've nicely shown how the ICC statute was actually not meant to be that kind of overarching instrument which guides all of the others, but it has grown into this almost implicit benchmark of reference. We see that in Leila's Crimes Against Humanity Convention. We see that in the practice of commissions of inquiry, etc. And I think one can take different views on that. To some extent, this might provide guidance, provides greater clarity. On the other hand, it also limits us in our imagination. So I think sometimes there might be a case to actually go beyond what is in the statute. You also pointed out that Article 21 is specific in the sense that it has this hierarchization of sources. It says in the first place the ICC should apply the statute. So if we have subsequent implementing legislation, the judges would still be in the first place required to give leeway to the statute rather than relying on general principles. So this is, again, I think, the unique feature of the ICC statute, which I think reinforces the argument that probably we will not see that much impact of domestic implementing legislation on at least the definition of crimes. I think if we speak about modes of liability, if we speak about jurisdictional issues, then it might be different. But I think so. I think this is really one of the particularities of the ICC statute. So thanks so much, Olympia. So now we pass on to Caroline, who will speak, follow up on the discussions on general principles. Thank you, Caroline.
Thank you very much. I have a slide, yes. The beautiful Article 21 of the ICC statute. So maybe I will discuss how maybe our imagination can come in handy when having a look at this article. As it has been said, this is the first codification of applicable law in international criminal law. So that's an important point, because this is meant as guidance for judges. There is a hierarchy very clearly, as Carsten just said. In the first place, the judges will use the statute, the elements of crimes, the rules of procedure and evidence. And this constitutes part maybe of what Olympia called the Rome system of justice. I love this expression. And then we have in the second place, with a little creativity here, where appropriate, applicable treaties and principles and rules of international law. And then thirdly, but maybe last but probably not least, because it's in there, failing that, so as a measure of last resort, general principles of law derived by the court from national laws of legal systems of the world, including, as appropriate, the national laws of states that would normally exercise jurisdiction over the crime, provided that those principles are not inconsistent with this statute and with international law and internationally recognized norms and standards. So it's already interesting because even visually, even though this is in the third place, it's the longest little paragraph with a lot of interesting expressions in there that probably need to be understood and interpreted. So already a little of a paradox here. This is supposed to be guidance. And yet when I started reading on it, I was thinking, okay, well, maybe I need guidance to interpret this guidance. So to focus, because that's my intention in the next 15 minutes on this paragraph C, my first idea was to, methodologically speaking, to have a look at the judgments, only the judgments, at least for now, of the court, to see when the court has actually referred to domestic system, to national laws. But then I realized actually, and as I will talk about, there's a bit of a reluctance of the court here. So sometimes it's the parties, so the prosecution and the defense, invoking national laws. Then I started reading, but then time was passing. And unlike what was discussed yesterday as to the committee, there's no word limit on the judgments of the courts. So this is very much work in progress. And of course, there's no keywords that I can use to actually make this research come up. So I have no other choice than to enjoy reading all the judgments. That's okay. So what I will focus on, the points I would like to make is first preliminary remarks as to the very concept of this rule. Why was it integrated within the Rome Statute? Having a look a little bit at the history of this disposition. Reflect on when it can be useful, and indeed maybe on modes of liability, or maybe it has been used for modes of liability. With crimes, I might have little different views. I think it could be of use with respect to certain crimes. And then I have a look at what has happened so far in the case law, looking at the International Criminal Court, but also others international criminal tribunals and courts, to then conclude a little bit of a, let's call it a nuanced conclusion. So as I said, Article 21 is the first codification. There is a hierarchy of sources here with national laws at the bottom of the pyramid. In a way, this is not very surprising. In fact, in probably most domestic systems, there is constitutionally a hierarchy of norms with international law superseding domestic laws. So it's not very, it's not an unusual pyramid, I would say. Yet maybe within the Rome system, what is interesting is that the cornerstone of this system of justice, as you mentioned, is complementarity, meaning the International Criminal Court and states work in a complementary fashion, supposedly on an equal footing. And here we don't have an equal footing. We have international law, domestic law. So again, conceptually, it's interesting. I'm not sure I can make a lot about this, but I just thought in terms of how this article was drafted and this hierarchy, I wonder how it interacts with complementarity. And in fact, the fact that ICL, International Criminal Law itself, is a hybrid system. It's a mix, and much has been written about how it was created, a mix of common law systems, civil law systems. And if we read the Rome Statute and the rules of procedure and evidence, we see this sort of dual nationality. And in fact, for some internationalized criminal tribunals and courts, this hybrid nature is part of their essence. If we think about the ECCC, a clear mix of international law and Cambodian law, and probably Cambodian law itself being influenced by French law. We have a similar sort of conceptualization with the special tribunal for Lebanon. So a mix of international law, Lebanese law itself heavily influenced by French law. So here this hybrid nature is very much admitted. And within the context of these international tribunals, we have domestic law and international law put on an equal footing. So again, I don't know how this hierarchy interacts with the complementarity and with the hybrid nature itself of ICL. But anyway, Article 21 was included the way it is drafted in the Rome Statutes. It's been mentioned already. I think one of the main concerns for the drafters was to respect the principle of legality. And supposedly in international criminal law, the concern to respect at all costs the principle of legality is maybe a little a little of an obsession since Nuremberg, probably because Nuremberg was too criticized, in my view, wrongly, for breaching the principle of legality, that now to make sure that the system is seen as fair as possible, because if it's to survive, it needs to be fair. The principle of legality is one of the chief concerns. So the idea was to really guide the judges so as to avoid extensive interpretation that would breach the principle of legality. So they've included this pyramid. And to focus now specifically on the language used in Article 21(1)(c), we see that it refers to general principles of law derived from national laws of legal systems of the world. So already terminologically, we don't have a reference to principles of civilized nations, like maybe we used to have up until then. In international law, we have the legal systems of the world. And in terms of how to interpret this provision, which was controversial, because some states were arguing that this should be interpreted really narrowly. It simply allows the ICC to identify and apply general principles of law derived from these national legal systems. There was a minority view arguing that this meant that the ICC could apply domestic law straight away. So there were debates and there were contentions. Now, having said this, it seems from the case law that what is clear is that the ICC will not apply national laws directly. That is not the idea, but rather these general principles. And Otto Trifterer and Kai Ambos have qualified this disposition as awkward, because it creates inconsistency inherent in determining these general principles by reference to specific national laws. Again, how is this going to work? And this awkwardness is admittedly visible in case law, and in the Ruto case, one of the trial chambers at the court said that, and I quote, "General principles of international law, including those derived from national laws, offer a basis to place an ICC trial chamber in an analogous position as a domestic criminal court," which is probably / definitely not what the drafters had in mind. So it does create some uncertainty, and it does create indeed an awkwardness. And okay, so if we just focus on these general principles of law derived from national laws of legal systems, but which legal systems are we talking about? Which national laws are we talking about? How are they going to be identified here? And in Erdemovich, in fact, so here going to the ICTY, the appeal chamber of the ICTY had actually started to explain this sort of method of interpretation, and had found, quote, "Our approach will not involve a direct comparison with the specific rules of each of the world's legal systems, but will instead involve a survey of those jurisdictions whose jurisprudence is accessible to us in an effort to discern a general trend, policy, or principle on the concrete rules of jurisdiction that we're meant to apply." So here it was interesting, because in Erdemovich, the appeals chamber makes an explicit mention of jurisprudence. So we're not in national law anymore. We're moving towards national case law. So I will actually talk about this briefly. At the court generally, so going to the International Criminal Court, there is a reluctance on the part of the court to actually use Article 21(1)(c). In several cases, it's been made clear by pre-trial chambers or trial chambers that national law and case law, so not only law, can constitute a subsidiary of law. In the Al-Bashir case, but also in the Bemba case, the court was very clear that Article 21(1) B and C, for that matter, could only apply if two cumulative conditions were met, i.e. the existence of a lacunae in the written law contained in the statute, elements of crimes and rules, and the lacunae cannot be filled by the application of the criteria provided for in Articles 31 and 32 of the VCLT that Olympia mentioned. So quite a strict interpretation of Article 21(1)(c). The parties tried to invoke it in some cases. In Lubanga, notably, the prosecution tried to use 21(1)(c) with respect to witness proofing, but only cited in support of its request for witness proofing two common law systems and left aside all the other systems. So that was rejected. The appeal chamber also in Lubanga rejected a request from the prosecution to disqualify a defense counsel who had previously worked for the OTP, and the prosecution only cited 5 jurisdictions in which this was inadmissible. So the appeal chamber rejected this. At the same time, and this links with what Carsten suggested, they accepted to import the control theory of co-perpetration within the judgment, and this was the object of a dissenting opinion by Judge Fulford, criticizing this over-reliance on German law. So there is generally reluctance. Likewise, in a Mutahura decision, the appeal chamber of the court also reminded the prosecutor that they could not rely solely on US law when the statute was clear. So relying only on one legal system will not work. So reluctance of the courts. Now, to sort of come to a close, all this begs the question of when Article 21(1)(c) could be useful, because yes, okay, it could be useful when it comes to modes of liability, but that was actually quite contentious, and it was criticized in academic works as well. When it comes to definition of crimes, and to follow up from what Olympia explained, that could be heavily problematic because national laws can really differ from international law. Yet in international criminal law, we have some open categories of crimes. For instance, other inhuman acts as crimes against humanity, or an open list of acts of sexual violence as crimes against humanity. Could national law be useful? Now, up until now, we have limited case law, but for instance, for the crime of forced marriage, the ICC relied on Special Court for Sierra Leone and to some extent ECCC rather than national law. The question can be asked whether this will be useful. Another question linked to this is whether it could be dangerous if we turn to national law, or in fact, national case law, because this holds a risk of really being lost in translation, because national case law is an interpretation of national law, which itself, if we talk about international criminal law, is a national embodiment of international criminal law norms. So there is a risk here of having several interpreters. Yet it hasn't stopped the international tribunals, at least, to refer sometimes quite heavily to domestic case law, in particular, but not exclusively. The Eichmann case has been cited in different cases, including Kristich at the ICTY, Akayesu at the ICTR. The Barbie decision as well as to the definition of crimes against humanity. So the French case law here was cited several times by the ICTY, as well as by the ICTR. Same thing with the French judgment in the Touvier case, again, regarding crimes against humanity. And that is all the more interesting insofar as the Barbie definition was probably less controversial, but the Touvier case contains serious flaws. And what's for sure is that the French definition differs from the international law definition, but it didn't stop the tribunals from looking and applying these cases. And in the end, was this a real issue in terms of interpretation of the law? Well, not really. In the end, what maybe this shows is that there is expertise in international criminal law, not only at the international level, but also at the domestic level. And maybe that is what the Rome system of justice is. And maybe this is what this article and the complementarity principle tries to achieve, a system of justice where international criminal law can be applied. Now, there can be, I think, there can be clashes, there can be inconsistencies, but in a way, I don't think it is an impediment to sort of successfully creating this system. And I will end there because, in all honesty, on my computer, I had a completely different conclusion where I thought, is complementarity possible at all? But it's, as I was talking, I was thinking, well, actually, maybe it can function. And maybe if we proceed completely by analogy, which is not allowed in international criminal law, but we have a look at the European system of protection of human rights here also, we have a court trying to create a system with a European consensus. And it does take time. And I think maybe this is what the International Criminal Court is trying to achieve as well. And I'll end there. Thank you.
Thank you so much, Caroline. First of all, I think you've shown us that the way of how interpretation is used is intrinsically linked to the provisions on applicable law in the different statutes. And here we see that we have discrepancies between the ICC statute and a lot of the hybrid courts and tribunals, and particularly in a lot of the STL. The Kosovo Specialist Chambers is, I think, the most compelling example of how you then have really a mix of very different sources which apply at the same time: constitutional principles, international legal principles derived from several jurisdictions. So it makes it very difficult then for the judges actually to decide what the law is that is applicable. Secondly, I think you've shown us that the ICC has been rather restrictive in its use of Article 21. I think the examples mostly relate actually then to procedure, to criminal procedure rather than substantive crimes, where the court has actually used this. And I think this raises an interesting question. Is it the difficulties inherent in the method of determining general principles that prevents the court from going into that exercise, or is it really this hierarchy of sources which is here dominant? If we look at the ICTY jurisprudence, of course, the Fuendria decision has been instrumental because it developed the definition of rape based on the national definitions of the crime. So you said, particularly in relation then to maybe sexual and gender-based violence, if we think about reproductive autonomy, there we lack guidance. So is that an area where in the future maybe the court might have to rely as well to a greater extent on developments in national law? A third principle I would mention is, I think, sentencing, because here again it's interesting. We don't have any principles on sentencing, and the reference to national laws and not incompatible with international law has relevance precisely if the ICC then, for instance, tries to adopt a sentencing regime which would also be closer in line with the domestic system, right, on whose territory these crimes have been committed. So here's again, I think, a very interesting field of application. And if we think about the Ongwen decision, the question comes: what is the appropriate sentencing for these types of crimes? And should the ICC then only follow its own jurisprudence on sentencing, or should it look to a greater extent also what national systems are doing? So I think here's an interesting scope of application where this might become relevant. So now we pass on to Leila on overzealous interpretation. So very excited to hear your contribution, Leila.
Thank you so much, Carsten, and thank you so much to the organizers. I wasn't sure how to pronounce TRICI, and so I've heard tricky a couple of times. And in thinking about my presentation for today, and apologies for not having an abstract, but the end of term was ended an hour before I got on the plane to fly over here. You've sort of heard both Olympia and Caroline toggling back, and Carsten to some extent, toggling back and forth between the concept of customary international law, the ICC, national systems. We have deep complexity in the international criminal law space. And the complexity tends to get overshadowed by the fact that we have an international institution now at the center of the system. And so when I was trying to sort of craft a useful contribution to the project and to this conference, I was trying to sort of coalesce a lot of thinking about how can one think about that in sort of a more holistic manner. So I'm going to present a few thoughts about it. And it's an unfinished work, but that's what I understood our project today was, in fact, to develop our papers and our thinking a little bit more. But as you can hear, and my title will probably change, although because a piece of it is overzealous, the other piece of it is under-theorized. And so I'm going to try to explain a little bit more about what that is. If we think of, and we can't think of ICL broadly as just the International Criminal Court, but if we start with the International Criminal Court for a moment, I think you've heard from both Olympia and from Caroline that the initial jurisprudence in particular of the ICC, in my view, has been overzealous in some ways in terms of its applicability of the legality principle in improper ways. I think the modes of liability jurisprudence is unjustified by the statute and also incorporated one legal theory from one national system improperly. I also think you see that in its atomistic approach to evidence, in the way it would overly scrupulously sort of pick apart a situation in evidentiary terms. And conversely, I think it was deeply under-theorized in terms of international criminal law, public international law, and thinking about the ICC as an institution. There was no Tadich moment early in the history of the ICC, and that under-theorization of sort of the constitutional principles undergirding this new important international institution, I think rendered a lot of the jurisprudence sort of a little rickety and incoherent. I think we're getting a much clearer balance in the newer case law, both in terms of thinking about the statute in terms of the Article 21 and the actual application of the substantive criminal law of the statute in Nitaganda, in Angwin. I think we're getting a much better balance there. And I think we're also getting a little bit more attention paid to sort of broad theories of international criminal law in the decision on Palestine, in the decision on immunities, in Al-Rahman. I don't think there's a Tadich moment yet in the ICC, but I think you can look at a series of recent decisions seeing that the court is sort of starting to find its voice. Again, one has to distinguish the ICC from the customary international law of international criminal law. As Olympia's presentation makes clear, national systems are equally, if not more important in many ways, but the ICC being at the center of the system, it's sort of natural. I heard yesterday some talk about constitutional versus not constitutional, et cetera. I guess I'm a constitutionalist in the Anne-Marie Slaughter, Larry Helfer, maybe Bardo Fassbender vein in terms of thinking about the international legal system. So I'm trying to be a little bit definitional as I write this paper and as I think about it. Also, I have to say, when we talk about ICL in the United States, we include transnational criminal law. We don't limit it to the core crimes. In my presentation today, I'm really just talking about the core crimes stricto sensu, created by international law, whose direct application would be at the international law level. And as Basuni would have written, the indirect application would be at the national level. So today I'm talking about ICL in a more European stricto sensu term. There are a couple of crimes that toggle back and forth between, are they really transnational or are they international? And we're starting to see a blending and a convergence of transnational crime and international crime, which could affect, but for this paper, I'm trying to limit it basically to sort of core crimes. The other thing I think to keep in mind is international, especially when I was hearing the discussion about the immunities case yesterday, I tend to think the International Court of Justice is insufficiently sensitive to the norms of international criminal law. It's an older system, right? The ICJ dates back to the 1920s. The international criminal law really, you know, at best you could start it with Nuremberg and then there's nothing until the 1990s. So it's a much more recent system. But as I think Judge Yusuf's dissent in the immunities case suggests, we have in the international criminal law area a focus on the individual as an actor and not just on interstate norms. And so when I think about the evolution of international criminal law in a holistic way, remember that the treaties that the Nuremberg Tribunal uses, which is sort of our constitutional moment, the moment at which our theory in a modern sense begins, all of those treaties, whether it was the Hague Convention of 1907 or the Kellogg-Briand Pact of 1928, they don't provide for international criminal responsibility. The remedy is reparations for breach. It's interstate responsibility. And so jurisdictional immunities, when you think of what it says about jus cogens, it's completely at odds with what the ICTY and the Forensia case talks about as jus cogens, which is that if you have a system of individual criminal responsibility, you can't at the same time create a crime and then have immunities applicable to the very crime you've created. And so that raises, it's a little bit beyond the scope of my paper today, but in a constitutional sense, the Forensia court talks about, and it is dicta in the ICTY, but it was an important sort of moment for international criminal law. It's picked up in the special court for Sierra Leone. It's picked up in the German immunities case of last year in the national systems, where whether you're talking about immunities, amnesties, universal jurisdiction, all the procedural / substantive elements that are needed for the effective enforcement of international criminal law for international criminal lawyers. I think those do attach to the jus cogens norm. And that's where you're seeing in the dissents, especially on the jurisdictional immunities case, the ICJ cites 7 cases from national, right? It cites virtually no state practice for its principle and completely ignores all of international criminal law. And what Italy, I think, was trying to argue in that case is that you have to look at the more modern iterations of what it means to be a jus cogens norm, and you can't simply go back to that. And again, when I think of that jus cogens idea in international criminal law informing the creation of the core crimes, right? I don't think, I think I heard Kelson mention yesterday, but I go back to sort of Verdross, to Vattel, to the idea of what norms do you need for an international system to function? Because you can't have norms that do not, you can't have sort of the existence of norms that could destroy the system itself. And I think that's where the international criminal law idea comes from, coalescing at Nuremberg. So I just wanted to put that out there a little bit in terms of the sort of the context, the holistic context in which we have to think about the ICC and its creation and the application of international criminal law. I've been seeing this play out in the debates on the crimes against humanity draft articles because I attended the ILC sessions at which they were being debated. And you could see the folks with an international criminal law perspective, the members of the commission that come from that, having a very different view than the folks coming more from the public international law perspective. And so it is just interesting. There's really quite a different ethos about when we talk about customary international law. That's maybe the beauty of this conference, is we're all coming from our different fields and looking at things differently. But in ICL, I think when we think about that, we think about it a little bit differently. And we're also seeing that debate play out in the ILC draft articles on the immunity of state officials from foreign criminal jurisdiction, where again, the public international law, interstate immunity discussion is really quite different than the international criminal law discussion a little bit. So I want to talk about as well a couple of other things. So the newness of our field, the newness of the field of international criminal law and its evolution, and it's much less well evolved in a sense than international human rights law, because we haven't had an international court at the center of our system until 2002, when it comes into force, and we don't get the first judgment till 2012, I want to say. It's either 2012 or 2010 in Lubanga. So so our judges, the cooks, I can't remember Larissa's analogy from yesterday, but our judges and our theorists didn't have a whole lot to work with in terms of the quantity, at least, of jurisprudence. And so the impact of the newness of the system on international criminal law principles by national and international courts, especially the ICC, I think you can think of it sort of in two parts. One is a failure to properly distinguish the interpretation of constitutional or core broad principles from the constraints of interpreting a criminal code. And what do I mean by that? I think back to, if you think of the European community treaties, right? And I used to teach European Union law for a long time, before it was called EU law, so that long ago. There was a wonderful quote about the European community treaties, about the European Union taking the form of an international treaty, performing the status of a constitution, and containing within it legislation, right? The function of legislation. And the same is true of the ICC statute. The ICC statute creates an international organization. It has organs, it has broad constitutional provisions of what is the international legal personality of that sort of institution. And inside that is a criminal code. So the legality principle that we're talking about really applies to the criminal code within the statute. And Article 22 of the statute tells us that. And Article 22 then doesn't necessarily apply to things like what is the jurisdiction of the court. There, maybe we're looking much more at the Vienna Convention on the law of treaties, et cetera. And so in the early jurisprudence of the ICC, we get mixing up of a lot of that, a failure to distinguish between the sort of constitutional or constitutive or broad principles of the ICC, what it is as an international institution and its jurisdiction, from the criminal court. And faced with an absence of precedent, and here's where I sort of started my presentation for today, and then I broadened it as I thought about it more, a tendency to pick up bits of descriptive language from earlier cases and turn them into legal doctrines. And that's something I've been thinking about for a long time. It's something we saw in the Barbie and Touvier cases, and it's how they get into these really bad definitions. And I'm going to give you a couple of other examples. Cases in which a court sort of waxes eloquent and describes something, all of a sudden that's picked up and turned into a new legal element in another court. And I don't know how we fix that. So I'm hoping that we can have a conversation about that. I've suggested that we need canons of interpretation at the ICC, and I've written one article talking about 7 canons of ICC interpretation that would apply to sort of the technical, the criminal statute within the ICC statute, not so much the broad constitutional provisions of the ICC, but it is a real tendency amongst national and international courts to just pick up a description, and to the next case, it turns into a new legal element. And it creates, I am a special advisor to the ICC on crimes against humanity. So I don't have a prosecutorial perspective on this, but I have particular sympathy for the prosecutor that has to deal with yet another new legal element in a case. So let me talk a little bit about this issue of constitutional or core broad principles. And I'll just touch on something that I'm writing another yet unfinished article about, that I've talked to Carsten about just a little bit, which is this delegation theory that's been popping about the ICC. So the issue, so the International Military Tribunal, Tribunal at Nuremberg and the ICTY sort of built really substantial case law on the core nature of international criminal law regimes. I wonder if that's the Zoom. Yeah, maybe. It's a Zoom. The Nuremberg judgment, Tadich, the Eichmann case, I think even in Barbie, not so much the decision, but the Advocate General's reports were really quite extraordinary in those, joined by the Special Court for Sierra Leone, lots of extensive jurisprudence from Latin America and the Inter-American system. They built a lot of case law talking about the sort of core nature of international criminal law regimes. And what happens when the ICC gets negotiated is the United States, which was, it had its own particular political predilections in the ICC negotiations in 1998, argued very vociferously that non-state party nationals couldn't come before the ICC unless their state basically agreed to it under the law of treaties. And there was a huge pushback against that, a sense that no, that just flies in the face of everything we know about territorial jurisdiction and about international courts and tribunals. And there was very little credence given to that. The article is still floating around. The ICC, the US isn't asserting it with respect to Russian nationals in the Ukraine situation, suggesting it really is much more of a political than a legal argument. But it was also asserted by Israel in the Palestine case, not Israel directly, but the amicus that did it. And the theory that was floated was that states, when they create the ICC, are delegating part of their own criminal jurisdiction to this new institution, and that therefore the institution itself can't have more than whatever the states delegate to it. And so this delegation theory, which I think again comes from the use of the word delegate in a non-technical sense, which then gets imbued with specific legal content by others. But it has been picked up even by the current US Ambassador for War Crimes, which now sort of has backed away from delegation, but talks about pooled jurisdiction, right? She talks about pooled jurisdiction. And when you think about that in terms of what I talked about in the constitutional theory, right? What is an international criminal court? What is an international institution? In the other sort of unfinished article that I have, I say that's just, that flies in the face of every reason why states create international institutions. They create them precisely to do things they can't do themselves. So think about the International Court of Justice. States can't sue each other in their national systems, so they need to create an international institution for interstate disputes. I have a whole list in this article of all the different kinds of international institutions that we create, including the WTO and the Law of the Sea Tribunal. We create them precisely to do things that states can't do within their national systems, endow them with international legal personality, et cetera. And in the early jurisprudence of the ICC, one got a sense that the court was reluctant to embrace that. I think that really shifted with the al-Bashir case. And I know the al-Bashir case is subject to some criticism, the big immunity case by the ICC. But I do think that in al-Bashir, we saw the court the judges starting to sense, look, we are part of an international institution. And international institutions have independent legal personality, and they have to be cognizant of the sort of constitutional or principles of public international law then that underscore the system. But that's an example, if you look at it, of where a word gets used in a non-technical sense. Even the prosecutor would talk about delegation, or you'd see it in one of the cases, and then it gets picked up and an entire legal theory gets created around it. In the Israel-Palestine situation, the argument is even more difficult than the non-party state national one that the United States initially asserted, because there the argument, and this was made in Germany's amicus brief even to the ICC on the question of jurisdiction, that because in the Oslo Accords, the Palestinians had agreed not to exercise jurisdiction over Israeli nationals, they couldn't then, even assuming they had enough of a state, because that was the preliminary issue, is were they a state that could actually accede to the statute, even assuming Palestine could accede, since it itself had no criminal jurisdiction over Israeli nationals, it couldn't delegate that jurisdiction to the ICC, and therefore the ICC had no jurisdiction. And so you can see with 123 states parties, if the source of the ICC's criminal jurisdiction is national law, you have a Swiss cheese court. And many states haven't even incorporated ICC crimes into their national systems, so they couldn't prosecute. And so I think that's an interesting example of where the ICC, you sort of need to go back to first principles to resolve that question. The other thing where we see this either under-theorized or sort of misuse or sort of incoherent interpretive approach at the ICC or in international criminal law generally is, and it's really interesting that Caroline mentioned Barbie and Touvier, because that is where I would go with that. So one of the descriptions of Nazi Germany in the pleadings in those cases was that it was a hegemonic state that had this Nazi National Socialist ideology, right? And so what happens is that the French Court of Cassation, sorry, this is my computer being downloading and installing software, is that the French Cour de Cassation actually takes that description of Nazi Germany and says, okay, you can commit a crime against humanity if you're a Frenchman, if you're working on the part of a state committing a state with a hegemonic ideology, AKA Nazi Germany. Now, politically, that was convenient, right? Because it basically meant that you couldn't get Touvier, especially for executing, you know, the orders of the Vichy government, or you really didn't have to acknowledge the anti-Semitism of the milice, which was the paramilitary organization of which he was a part of. You could just say, no, he was executing the Jews in the massacre at Rieux because he was carrying out German orders. And so that was sort of convenient. But it's also an example of how descriptive language all of a sudden becomes a legal element. We've seen that with persecutions. In the IMT judgment, they talk about the persecution, the systematic persecution of the Jews, which again gets translated into a legal element. We see it in the civilian population requirement. The word civilian is in the IMT charter, so it has an old pedigree, as old as 1945, when crimes against humanity is created. There's no treaty at all creating crimes against humanity, at least for war crimes and crimes against peace. They had a couple of treaties they could convert to international criminal law instruments. But the word civilian in that sense was meant as a descriptor in a sense, and it was a new crime in which the attacks were against the civilians living in Germany as well as abroad. And so it had a very broad ambit. In wartime, the ICTY was asked to interpret the meaning of the word civilian and used Protocol 1, that is international humanitarian law, to come up with a very technical definition of the word civilian, meaning non-military, right? You're going to use Article 50 of Protocol 1. Well, what happens when you apply crimes against humanity in peacetime, which is over 30% of the cases at the ICC? All of a sudden, that Protocol 1 definition doesn't make any sense. What if a state is purging its military on an ethnic or political or racialized basis, which was the Khmer Rouge situation? So that, again, you're seeing sort of descriptive language turning into legal elements hardened by the use of international humanitarian law, interpreted into the ICC statute for crimes against humanity, which is now applicable in peacetime. And what's really interesting is at the ICC, there's been a clear understanding that the word attack on the civilian population does not mean a military attack. So their ICL and IHL have had their divorce, which they should have, but they're still bound together in the meaning of the word civilian, which is probably, that's what I meant by overzealous. And I don't know that that's the right word, but it's incorrect. I think also, finally, in the modes of liability jurisprudence of the court, this is another example in which statutory text was taken, parsed overzealously, I would say, and a definition and a departure from sort of existing customary international law was undertaken that wasn't necessary in a plain reading of the ICC statute. And so maybe ending where Caroline began with Article 21 of the statute, I think the decision of the court to stop at 21A and say I can't go to B unless the Vienna Convention fails me is again I think that's an improper interpretation of the statute. The statute tells you that the ICC has to be read against the backdrop of customary international law. And I'll just say one last thought about that. And again, then I'll finish this presentation. The reason the ICC statute has to be so deeply linked to customary international law is because of the jurisdictional regime of the statute. That's why it's hard to put something like a new crime like ecocide into the statute, because the ICC statute can apply to every human being in the world, even the nationals of non-states parties in cases of Security Council referral. I don't personally think the Security Council can create law. I know that there's some dispute about that in the Koskaniemi's report on fragmentation. That we could have a conversation about that. But I think the only way coherently to say that al-Bashir was subjected to the ICC, or that Russians are now subjected to the ICC because Ukraine has said my territory is covered by the shield of the Rome Statute, is because in fact it reflects customary international law. Now, what happens when that law evolves outside the Rome Statute system, as Olympia has said, Article 10 says it can. I don't know. And I think that raises a really difficult question for the Rome Statute. But I think in thinking about the ICC statute, for the judges to make sharp departures from customary international law ignores the system in which the ICC itself is embedded, which is a system of universal jurisdiction and universal applicability, even for the Rome Statute. It is a universal jurisdiction court with preconditions in cases of state party or prosecutor proprio motu referrals. And so that's why I think it is really important what Caroline was talking about, to pay much, much deeper attention to customary international law and general principles in interpreting the statute, and raises some really profound theoretical challenges in terms of the relationship of Rome law to non-Rome law through the guise of Article 10 and the continued creativity of national systems. So thank you. I hope I wasn't too jet lagged for it and it made some sense, but I really am looking forward to your comments, and I appreciate the invitation to be here.
Thanks so much, Leila. I think for a fascinating presentation. I think you go back to this idea which was raised, the ICC as a system of justice. And I think one of the most important controversies is indeed the one which you've raised. Is the ICC statute, is it a system of justice which is only founded upon state delegation, or is it founded on something more? Is it founded on the jus puniendi idea, on the idea of a social contract between citizens? So it's only the exercise of a much larger regime that actually underpins the foundation of the statute, and the delegation theory kind of blends this out. And this is where a lot of the systemic difficulties come from. If you look at al-Bashir, it's a step into the jus puniendi idea partly, but we have, as you said, incoherent jurisprudence. The ICC has not decided yet what it's actually about. So it's really the macro question which is still out there, which then has underpinnings about how we go about interpreting the norm. I think maybe there's one point where I would disagree about, you said about this distinction between state responsibility and individual criminal responsibility, that this might be a way to really say how the two systems can be really distinguished. I would be a little bit critical of that, because I think we make it too easy if we say that international criminal law is only about the idea of individual responsibility. I mean, the crimes are collective, the contextual element are reliant to a large extent also on state involvement. So to kind of see them almost as diametrical opposed systems, I think is a shortcut. It takes it too easy. So this is why I'm a little bit divided about this this line of the ICJ in Bosnia versus Serbia as to try to find a way out to explain the constitutional differences. But let's open up the floor for debate. I think we have some people online and people in the room. So please go ahead.
First of all, thanks to all the panelists for these very interesting presentations, especially it's always difficult. The first panel on the second day is always a tough one. So you've done a fantastic job keeping the attention of sleep deprived and alcohol infused audience. Fair. Sorry, Andre, I was joking around. I didn't mean to insult you in any way. If I'm permitted, I have a question for each of the panel members. So I'll start with Professor Bekou. I completely agree with you that we need to have a clear line between, on the one hand, interpretation, and then when we're going extra active there, we end up with modification. One question that I have is, how do you think the recent work of the ILC on subsequent agreements and practice and the conclusion, I don't remember the number, I'm terrible with numbers, where they basically said that, well, in case of doubt, we go with a kind of that we always presume that we're interpreting rather than modifying. Do you think that this could be, let's say, feed into your fear that maybe some of the more activist judges will hide behind and kind of use it as an excuse to say, oh, no, this is not, we haven't gone beyond what we are allowed to do. We're simply interpreting that there is this presumption. Then to Caroline, again, this will be a question about the ILC with respect to their work on general principles there. And if you think that might help understanding the wonderful article on applicable law. And added to that, my question was, because in the language of the text, it also refers to, especially by the domestic legislation of the state that can prosecute the crime, whether that is kind of a hint of a a specialized version of identifying general principles. Does it kind of hark to specially affected? So the idea of specially affected states, for instance, or do they try to introduce? Because I have absolutely no familiarity with when they were discussing it, what it was. So if you had any thoughts on that. And then finally to Professor Sadat, you mentioned that this is about another article that I'm not sure if you have written or is in the works of being written, but you mentioned that you suggested certain rules of construction. And I would kindly ask if you could elaborate a little bit on that, on whether, so are these articles, do they diverge in order to tie with the theme of the conference? Do they diverge from the rules of the VCLT on interpretation? And if so, for what particular reason and in what particular way? Thank you.
Okay, I'll go first. I did think about the recent work of the ILC when I was preparing this, and I thought I'd dodge the question, but clearly I have been found out. I think I might go a bit conservative again and say, to my mind, I think what I can't reconcile with that ILC piece is that this is a criminal law. So I think I'm not sure the judges can hide behind the ILC proposal, because we are deciding guilt or innocence. So it's not a general international law piece where you could say. So I guess I'm coming across as very conservative today, but I'm not sure you can stretch to say, oh, this is subsequent agreement and practice, therefore it's okay, when you're deciding whether you put someone behind bars. But I understand that this may be a cop-out, and it may be more complex than I think it is.
Thank you. And thank you for your question. And yes, I would agree.
Yeah.
So yeah, I also think in the context of Article 21(1)(c), it's very much like, going back to the actual text of the article, these general principles of law derived from national laws. So it looks a little bit more like an individualistic approach rather than general principles, if that makes sense. This derived from national laws, thank you, of legal systems. And with respect to how this disposition was drafted, and again, Trifterer and Ambos note that there were two options there for the court. Either, well, use general principles of law derived from national law, or option two, apply national laws directly. And the result actually that we have here is a compromise, meaning you apply general principles of law derived from national laws, and you can use specific national laws maybe as examples to sort of prove the fact that there is a general principle of law. Now, where it gets a little bit confusing is what you pointed out, including as appropriate. So it's not especially, but rather including as appropriate, the national laws of state that would normally, no idea what normally means. Also, is that, I mean, I'm French, but is that proper English? Shouldn't it be usually? But I don't know, but I don't know what normally is here. Exercise jurisdiction over the prime. And there was one commentator who said, well, although universal jurisdiction is not part of the Rome system, but couldn't we say that if states exercise universal jurisdiction, then that's every state? Or do we mean these states which have a particular interest in the situation? So do we go back to state parties or the territory where the investigation crimes have taken place? But it's interesting, but I wonder whether this is, but this is just me thinking, so don't cite me on this. But in terms of the terminology, as I mentioned, we have a reference to legal systems of the world rather than principles of civilized nations. So we have an evolution here in the language. Whether this is also to make sure that maybe the states which are being investigated, or including states which might have self-referred to the court, are not cast aside, and that their laws could be taken into account. So maybe this is a clever diplomatic move, because I'm not quite sure why it's necessary to have this specification, including the national law of the states that would normally exercise jurisdiction over the crime. Well, yes, they're part of the national laws of the legal systems of the world. So a little bit of confusion here, maybe, but maybe sort of political drafting here. Also, maybe to avoid criticism of national bias on part of the judges, because supposedly if they're going to turn to national laws, they need to have knowledge of these national laws. So it means that this might be heavily influenced by where the legal officers and the judges come from or receive their legal education. And that's not, and no pun intended, that's not judgmental. It's just a fact. We all come in, and as academics as well, with our own, so let's call it national bias, depending on where we've been educated. So I might have positions on certain scope of certain human rights. I'm thinking Article 10, freedom of expression, because I was educated in France, and I probably here would join more people educated in Germany than people educated in the UK. But there's no judgment of value here. I can't remember where I was going from that. But all this to say that this is probably an attempt to put all these national laws on an equal footing to avoid criticism as to Western colonization, and criticism as to judicial bias, and to avoid judicial bias. So maybe this is also guidance for the judges to say, remember to have a look at, I don't like the word, but the local laws of where the crime actually maybe were committed. But I have absolutely no authority to support what I'm saying right now. I should just say, apart from my own, which is nothing.
Just to two-finger on that, Caroline, I think it came up in sentencing because it came up in sentencing, to go back to Carsten's point, in the Yugoslavia tribunal of looking at the national laws.
Yes.
And in the case of forced marriage, there was floating around, and I'm misremembering which case it was. There was floating around the defense that what I was doing was lawful. And the response was, the laws of your country have very specific requirements for marriage. And everybody knows what those laws are. It's not a defense. So I think it can come up in really interesting ways. The defense could raise it. Like what I was doing was actually legal in my country. Of course, if there's a hierarchy, the Nuremberg principles say the domestic law is not a defense, but it could be a defense in another, I think. To your very kind point, yes, it is actually a published article. It's called 7 Canons of ICC Construction. I actually had to pull it up. I was saying before the thing, when you write a lot, sometimes you forget. You're like, what was I actually saying in that piece? It was a response to the modes of liability jurisprudence in particular, assuming that Article 22, the legality principle, applied to it. Here is the relationship between Vienna Convention on the Law of Treaties and sort of the principles Caroline was looking at, which is you look at the text, you look at plain meaning, you look at the context, object and purpose, etc. And then if you have, but you have to be consistent with the legality principle in Article 22. Then Canon 3, if you have ambiguity or obscurity or manifestly absurd, then you go to Vienna Convention, you can look at the travaux, etc. And then if you have gaps, you go to the particular sources. And then I added a couple additional ones because I think that in thinking about their canons of construction, given my point, is the the judges should be sensitive to the fact that this is a system and they should try to avoid fragmenting the system if they can. And that's my personal view. I don't think there was any reason they had to make the sharp departure from the existing system of jurisprudence that we had at the ad hoc tribunals. It's confusing. When I teach this to my students, they kind of want to kill me for how complicated it is. I'm like, don't blame me. I didn't create this law, but you have to teach all the customary international law at the ad hocs. And then you have to teach indirect and direct co-perpetration at the ICC. And you kind of want to shoot yourself by the end of it. And so why fragment it? Because in fact, it's like, and I call this a Rorschach blot. Everybody reads their own system into the language. When I read it as a common lawyer, I see joint criminal enterprise right there in Article 25 3D. I don't have any problem with it. Whereas other people don't see that. So it is actually a 7 canons of construction, 5 of which really are based on what Caroline was talking about, which is that interplay between Vienna Convention and Article 21. And there's also that really interesting provision of 21.3, which says you have to be consistent with international human rights law, which is, I think, a really fantastic addition to the ICC statute. And one that has to kind of be threaded all the way through interpretation. Yeah.
And which, if I may, probably would mean that the national laws, if used, also need to comply with human rights law. Yes. Supposedly. So you wouldn't be able to invoke a national law that would, let's say, allow for gross human rights violation, because that would contravene 21.3, I would imagine.
Yeah. Well, that's what I said is every application of law has to be construed with the objective of protecting the rights of the accused and ensuring the international human rights. So, yeah, I think it would help the court to develop more strict canons that way. I mean, we call them canons in our system. They could be called something else.
So we are already a little bit over time, so let's collect a few questions now and to pose them then collectively to the panel. Please.
Okay, thank you for this really wonderful papers, and Carsten also for your comments. So I have a specific observation and question on Leila's paper, and also something that then Carsten already picked up on. And I actually quite agree with you that the ICJ is trying to shy away a bit too much from the international criminal courts and tribunals, and trying to ensure that they would be kept out of the system, so to say, as something special, almost peculiar. And here I also agree, that the ICJ probably was not quite correct in how it in Bosnian genocide rejected any relevance of Tadic by saying, well, but Tadic is about individual criminal responsibility, and here we are talking about state responsibility. Well, okay, so Tadic overall was about individual criminal responsibility, but then when it was a question about which armed conflict it was, and there, so I think in Tadic the tribunal was quite right in applying the certain attribution rules, into which I guess then the ICJ did not want to go. Or another example is in jurisdictional immunities, which you mentioned, that I think the ICJ sought an easy way out with this distinction between procedural and substantive law, where, yeah, so immunities may be procedural before Italian courts, but are not procedural before the ICJ. Say if Italy does not give immunity, so Italian courts do not recognize immunity to Germany, that is then a question of potential substantive violation of immunities. But so in principle, I agree with that the ICJ is trying too hard to not to properly systemize the criminal court and tribunals. However, I'm still questioning whether immunities, the question whether the immunities are transposable or systemically transposable from the setting of criminal courts and tribunals to general public international law, because what we have with the immunities is that statutes of these courts deal with the immunities, but then when you transpose them, try to transpose them to general public international law, we have their immunities that are applicable under custom, and then we do not have any treaty or Chapter 7 resolution or any that kind of source that would override them. So this is why then I would question whether we can really transpose them like that. Okay.
So let's collect a few more questions that we take them together.
So thanks for the great papers. I really learned a lot, but it's not my field. So I have more of an adjacent question, if I may, in light of what came up yesterday. The topic there is, of course, it was now about substantive provisions of ICL, but there's as I think Leila mentioned, they're touched upon, there's also the constitutional part, or Caroline, there's the constitutional part of the statute as well. And would you, sort of as a general question, is there any instance of object and purpose interpretation for that part of the statute, which in the end could have an effect, of course, also on the application of substantive ICL? So I have no idea. So some people insist that courts are international organizations, and some people, like myself, actually wonder whether it is anyway helpful to look at it that way, but would be curious.
Andre de Hoog, University of Groningen. I'll leave the immunities to Eurus question, because I think Al-Bashir is wrong on so many counts. You know, I don't want to go into that. But the point of the delegation issue combined to possibly the issue of jus poiendi of the international community is very interesting. And I kind of follow you in the sense that basically substantive jurisdiction is kind of universal in the sense that any person could potentially come before the court, but then preconditions have been put in, you know, to kind of limit that. But I know this jus poiendi is also very much kind of promoted by our good colleague Klaus Kress, who's now also ad hoc judge. But the problem is that the international community can only really act if it has an institutional component. Now, the UN has that, but the ICC has been set out outside of the UN system. And you can't say that 120 states out of, you know, 193 or more, you know, then represents this international community, because it's not institutionalized in that sense. You know, too many states stay out of the system, you might say. Now, of course, we see the Security Council referral as a kind of jus poiendi construction, but then we go back to the UN again. But most of the other aspects are actually kept outside of it. So I don't take that. I don't think we can say, just because the claim is in the preamble that these are the crimes of concern to the international community as a whole, that means the ICC actually represents this international community, because it's treaty-based, it's consent-based to a large extent, and it's only the referrals and the deferrals that kind of bring it back to the UN, I think.
No, my comments are probably
so I'll try to be very quick. So my first question goes to a point that you have raised, both Professor Sadat and in the Q&A by Professor Bekou, about a kind of ethos of international criminal lawyers. And this translates into an interpretive approach, which is close to the VCLT, plus something special, a little bit of something criminal, right? So, and I would like to interrogate that in light of what Professor Stahn has said, because I find something, I would say, unsatisfactory. It leaves something, you know, some more justification, the idea that someone ends up in jail if we don't interpret things restrictively. And one might say, okay, yes, but the DRC versus Uganda case before the ICJ was about $18 billion, which might have brought a state to its knees. So would that elicit a restrictive approach? And the other question, and perhaps with the ASP coming up, is if we take the point that I think we have proposed in a way in the description about unity, is the ICC fit for purpose, for the purpose of unity, or for if unity is a purpose in itself? And I'm talking about its composition and the fact that at least A judges are not necessarily trained in international law. I guess it was designed to fail if it was an international court, and whether these should be reconsidered in a way.
So thanks so much, I think, for a set of really, really interesting question. I think, as you rightly said, the ICJ in the Uganda reparation decision left out this crucial aspect where there's a limit on reparation based on the capacity of the state and its impact then on the individuals. So this is where it becomes, indeed, I think, a little bit blurry. Where do we put the limits? Can reparations not also be a punitive instrument, right, which has similar functions as criminal punishment? So I think that's a very good analogy. So let's walk through our panelists. Each of them might have something to say on the different questions. So Olympia,
Okay.
please go ahead.
Where do I begin is the answer. I think we have to be honest that as international criminal lawyers, we tend to take the moral high ground a lot of the time, right? In some respects, we think we are kind of better individuals because we are in that international criminal law sphere in some respects. And I get it, you know, you're challenging us today to say, are you really better or you think you're better? I'll try to answer Kiki's question and Sotiri's question in kind of in the same sort of sphere. Kiki, the example I can think of in terms of the constitutional part of the statute actually came through a discussion of the preamble of the statute, because the duty to prosecute can only be found in the preamble, which is not binding. And you had a lot of people at the beginning of the Rome statute thinking, okay, so we've created a statute. Surely everybody understands there's a duty to investigate and prosecute. Yes, but it's only in the preamble. So I think this is the closest example I can think of the object and purpose in kind of in the broader sense that you put it in your question. So there is the ethos of ICL. Yes, I mean, I think you're right. It's Vienna Convention on the Law of Treaties and something special. I take it that it is unsatisfactory, but this is why I am saying, okay, we are taking the moral high ground here. In some respects, I don't think money is the same as putting someone on jail behind bars. I'm sorry, I think it's different. In the issue, is the ICC fit for purpose? There is a lot of debate, and again, with the ASP in mind that some of us are attending, there's a lot of debate at the moment on intersectionality and how we can improve the ICC to take into account all the other aspects that perhaps we have ignored and created a court which has, I agree with you, the composition of the judges is a compromise. List A and list B, people who have never done a case before, but they were very good diplomats and had to be on the court at the beginning. Maybe it's not serving us very well right now. Will this change? I don't think so. I think, you know, again, we go as far as the states that set up the court want to go. And this is an area that perhaps can't change. So they're trying to change it through amendments to the rules of procedure, amendments through the way we've seen the expert review that highlighted many of the independent expert review highlighted many of the inefficiencies and inequalities within the court. So there are efforts to change the court from within, and definitely the new prosecutor has come in to shake things up. But I'm not sure we will change the statute that easily, because the balance that was achieved in Rome and in Kampala with aggression is just so fragile that I don't think there's an appetite to change it anytime soon.
Thank you. So very briefly, with respect to object and purpose, that is a really interesting point. When I was researching for this paper in particular, I came across some judgments, but actually at the ICTY, but it doesn't mean there's none at the ICC, where the tribunal was referring to the object and purpose of the establishment of the tribunal. So, you know, that kind of, which supposedly is, the object and purpose is to end impunity and to prosecute crimes, international crimes, the core crimes committed in that particular region. Now to go to the ICC, is the ICC fit for purpose? Is it designed for unity? There is debate, obviously. And to be honest, like with my conclusion, there's debate in my head. And today I've decided to be optimistic. It wasn't necessarily the case yesterday, might not be the case tonight. So I'm a very confusing lecturer for my students, depending on the days. For sure, it's not perfect, does it? But that's the thing. And then it goes back actually to object and purpose. What is the purpose of the ICC? Is it to have one court in The Hague that's gonna take the most important cases, cost a fortune, even if you could say domestic systems, also judicial system do cost money, and have a sort of elite justice? Is it this? Or is the ultimate purpose of the court to try and establish a culture of international criminal law? It's a very recent legal corpus, and to sort of put this high on the agenda of states And probably the most exciting developments are happening at the domestic level. And there are some trials that are going on, not really relayed in the media or in a lot of academia. There was one particular case in Kavumu, a little place in the DRC, and they held this trial of 11 military high-ranking officers for the abduction and rape of little girls. And they were convicted for crimes against humanity. This is, however, that it's difficult to get information on this trial because no one talks about it. But for me, if the purpose is to create a culture of international criminal justice, and if the ICC, the creation of the ICC gives the sort of impetus to do this, then I would say, yes, it is fit for this purpose.
So the ICC is clearly not only a retributive project, and I mean, this expressive function of the court, I think, is key. And for that, you need a certain coherence in the jurisprudence. Otherwise, you're not able to deliver the messages about, you know, what ought to be achieved, what states should do. So, and this is why I think one of the good proposals in part of the expert independent review was also to at least provide guidance if you want to deviate from the jurisprudence of an appeals chamber decision, that you actually motivate why you do that you give clearer reasoning so that at least others understand why you do it. There might be valid reasons to deviate from the appeals chamber, but you have to set it out. You have to be more transparent. And I think this is key where the system really needs to improve. Leila.
Yeah. So on the specific issue of the ICJ, ICC, on the immunities, I'm not super critical of the jurisdictional immunities decision, quad decision, within the context of public international law. The dissents, honestly, Judge Youssef, Cansado de Trindade, that resonates more with me, right? It's when that case gets transported back into international criminal law that my hackles go up, because that, to me, is an incorrect application of an interstate issue. So I think we're actually in agreement. It's not so much the decision, quad decision, which it's contestable, but it's perfectly within the ambit of a reasonable interpretation of the law of immunities in interstate disputes. When that interstate dispute immunity, however, then gets translated back into the draft articles on crimes against humanity, we had some very, very lively conversations about immunities in that context. And that's where I think you can't take an ICJ decision on a different issue and sort of then bootstrap it into international criminal law. That's what I didn't like. These are so interesting questions about the ICC being outside the United Nations system, about object and purpose, and is the ICC fit for purpose? And what I would say is, in fairness to the judges, about whom I'm somewhat critical with some of the jurisprudential decisions, the reason there was no Tadich moment is because when the statute was negotiated and right afterwards, there was a lot of criticism of judicial activism at the ICTY. And I think that the judges probably internalize. I mean, I can't speak of every single judge, but I think there was a collective sense of, oh, we're not supposed to be like those ICTY judges. We're going to just apply our statute, and we're going to be more technocratic and not wax eloquent about the meaning or universality of the court. And I think the judges are realizing that actually that produced some poor decisions, honestly, because it was sort of overzealous. That's my word, parsing of language to the point that it became not terribly helpful. And I think as the system matures, that's why we're not having a Tadich judgment. I tell my American students, Tadich is sort of the Marbury versus Madison of international criminal law, because they can relate to it then, right? It's kind of this foundational. We don't have that at the ICC, but I think it's because, in fairness to the judges, they were a little scared to do that, because the clear sort of sense of states was, don't go, making this stuff up, like no judicial activism on this issue. That's why I'm so keen on the attachment of the ICC statute to customary international law, because if you lose that, if you go back to the theory of why did we get to do Nuremberg in the first place, which was pretty astonishing. It was this idea of, if you go back to, I was lucky enough to do some of my training in France and reading a lot of those early Swiss and French scholars, the Europeans' interwar scholarship between World War I and World War II, whether it was Pella or Lambois or Aranono, all of them are writing about the need to protect international public order, that you have this idea of l'ordre public international, and that you can have this system create this international criminal court, and that goes back to the 1920s actually, in order to protect public order, right, at the international level. It's almost jurisdictional. Why do we get to have an international criminal court? Because the international community needs this in order to maintain public order, and it's sort of a response to the failure of the Versailles experience with the trial of the Kaiser. And so at Nuremberg, it's this weird marriage in my mind of sort of all the civil law thought that's being developed in Europe that's completely ignored, by the way, by the United States hates it, the Brits hate it. But then during the war, they get really mad and they're like, okay, now we're going to have a trial and this is going to happen. And so all of a sudden, to me, this civil law theory, this European sort of ferment that's going on all through the 20s and 30s, really, and the early 40s gets married to this, and now we're going to get it done. And this Nuremberg moment happens. There are 19 states join the 4 with the Nuremberg Charter, so it's 23 out of 55. It's still not really universal. The Nuremberg principles are then adopted or, drafted by the International Law Commission in 1950, and the General Assembly adopts the Genocide Convention, et cetera. And I think there is this sense of universal jus cogens norms, again, going back to the earlier, to Verdross, to Vattel, to this theory that's developing in Europe during this interwar period. So the ICC, to my mind, to be able to, for al-Bashir immunity decision to work, or for it to have universal application through the guise of the Security Council, it has to tie into that legacy of, and that's why I do agree with Klaus, that has to be the theory upon which the ICC is constructed in order for the jurisdictional regime to be ethical in a sense, because how else could we apply Rome law to non-ICC states parties unless it's universal law in some way, unless we think the law, it has to have that rattachement, right? It has to be applicable. And so that is the theory, and that goes to what is the ICC. They knew they couldn't get an amendment to the UN Charter, right? That would have been best. So it is a separate treaty court, but it's a treaty court with those deep roots in the international criminal law system. It's why I'm the skunk at the garden party on the crime of ecocide. I just don't see how you could put ecocide into the Rome Statute now, consistent with that conception that I understand of the Rome Statute, which is that it actually has its origins in that interwar period, in the Nuremberg moment, in the ICTY. And I do see it as the next in line of that legacy, in spite of the fact that we don't have universal ratification of the statute. So I don't know if it's fit for unity. That's the goal. I've never heard, it's so interesting you raise it. The criticism is always of the the international law judges, that they don't have the criminal trial experience, never of, I love that there's some criticism of why don't those criminal law judges have international law experience. So I really appreciated that particular comment, because that's not what we usually hear. Yeah, thank you. Sorry.
So I think this concludes a wonderful panel. I think we've completely failed on time, but I hope we have succeeded on content. I think we had some wonderful presentation. We had some really engaging discussion points, and also from you. So I think it gave a really, a realistic picture, on both. Some of the things where the ICC has pushed the boundaries for international criminal law is really innovative and forces us to think anew, but also some of the critiques and limitations and incoherences that we still face. So thank you very much.